Ria Bond.
Thank you, Mr Speaker. I'm pleased to rise on behalf of New Zealand First and speak to the third reading of the Patents, Trans-Tasman, Patent Attorneys and Other Matters Amendment Bill. I want to point out to members in the House this afternoon that New Zealand First in the first reading of this bill, we did support this bill to ensure that the bill went through the process of the Select Committee. Because at the time, for what it seemed, this bill seemed quite like it was a straightforward bill. It had all the answers to fix all the outdated problems to do with the patent sector, that it was going to help alleviate the issues that the 2013 Patent Act had actually come up with. We also noted that the bill did have poor drafting, and that kind of alluded us to the fact that yes, there was a comprehensive look and redrafting of the New Zealand Patent Act 2013, and that took effect on the 13th of September 2014. And we knew that that had been a mammoth task, and that it seemed that the Act had been spun on its head with the sweeping and massive changes. And our concern was that we were here again, not 2 years, but 18 months later, looking at the unintended consequences that those changes at the time to the Act actually left to the sectors and industries. So that is why we did support the bill to the Select Committee process, and I have to say that as well as other members in the House have spoken on today and in the committee stage and second and first reading, that we're pleased that this process did in fact occur. Because what this bill did seek, it would seek to amend the Patents Act 2013, and a large part of those amendments originally proposed was an amalgamation of a single application process known as SAP and a single examination process known as SEP, so that there was finally a Trans-Tasman regulatory regime for patent attorneys. But throughout the Select Committee process, this bill, Mr Speaker, sadly fell apart. It actually hemorrhaged, Mr Speaker. One of the reasons was that a policy decision was taken to produce a parallel system to that being undertaken globally without the due diligence required. The biggest problem the committee became faced with was getting solid evidence out of our advisors and our officials that had been assigned to us. We pressed our advisors to provide the members with a cost-benefit analysis which could demonstrate the actual value of the pilot program supported by that minister inside of this bill that we knew as the SEP and the SAP. So we took and asked the minister not once, not twice, but actually 6 times to reconsider this bill and to pull this bill and actually go back over and make this bill fit for purpose so that it was good legislation being passed in this House, not actually legislation that was wasting members' time. But that fell on deaf ears, Mr Speaker. It was quite sad that that fell on deaf ears because the other issue, the major problem, was that there was no pre-consultation either with New Zealand innovation businesses or the patent attorneys on the viability or need for the SEP and SAP system before the legislation was in fact drafted. We did hear from 20 submissions that included 2 supplementary submissions, and we heard 6 oral submitters. From this, the committee had an absolute overwhelming opposition from the patent attorneys and submitters to the SEP and the SAP system. We also had major criticisms to implement a single Trans-Tasman registration regime for Australia and New Zealand patent attorneys. Despite this high level of criticism and this absolute concern and the feel that there was ignorance and arrogance when this bill was being drafted, this area has still stayed in the bill, and we're debating with that on the third reading today. Mr Speaker, again, this did highlight the fact that the Minister's advisors had not taken a pre-consultation or in fact any type of thorough consultation at all with the patent attorneys or innovators. And the industry itself, Mr Speaker, only got consulted with throughout the Select Committee process when they could be heard. And I want to point out that this not only was that bad behaviour with the advisors, but it was also really poor practice that we would actually have to witness this. And I questioned at the time the issue with, it was glaringly obvious that an advisor had a personal interest in this bill, and you know, the advisors actually we're of high concern, and I'm sure other members will say this, that when pressed and pressed, we just got no solid evidence at all back from them. We did, as a committee, and look at some secret papers that we're not allowed to talk to, and I won't do that, but it's hard because those papers alluded to the fact this bill was not fit for the House. So, Mr Speaker, the situation still remains the same, is that New Zealand First believes that this is a poor bill. Although it's had the amendments brought to the House in there, it still has issues with the industry itself coming back and telling us that this is actually going to diminish the very industry that this bill seeks that it's going to protect. We have also heard that from previous debates in the House that the origins of the joint regulations are pretty murky, and that the SAP and the SEP were a pilot program. They were part of the Single Economic Market, SEM, an initiative announced after a prime ministerial meeting between John Key and Kevin Rudd in August 2009. This joint registration almost is like good luck to the last man standing. And to date, the committee and members are still faced with the mystery of how the government actually got to that single signal of how this would transpose and be good, and it does remain a mystery today. The merits of a joint regulation and standalone New Zealand regime is still faced with multifaceted innovation market and patent attorneys that service it. And if you would permit, Mr Speaker, I'd like to quote from an article that was written by Doug Calhoun. And what he says is that the regulatory impact statement cost-benefit analysis table compares existing regulatory fees with the fees under joint regulation, making the unlikely assumption that joint regulation fees will remain the same as the current Australian fees. The listed cost regulatory fees are taken out of context. Regulatory fees make up only a minute performance of the cost of patent attorney services to businesses. The list of costs also does not include the extra costs that will be imposed on New Zealand candidate attorneys that will need to take Australia's qualifying examination in order to become registered. They do not include the administrative and travel costs of expanding the Australian regime into a Trans-Tasman regime. Too much has been left out. So finally, Mr Speaker, what was pretty much a straightforward inside of this bill is the proposal to create an unintended consequence, which is to amend the grounds in which a person can oppose a granting of a patent under the Patents Act 2013. This is a correction of a drafting error in the Act 2013, and in order for the Act to meet its original policy, the intent this anomaly needed to be corrected is correct. However, I wanted to say that the New Zealand Law Society printed an article that said the proposal to retrospectively bring in regulations for old patent applications would be unfair for all businesses that made patent applications under the previous law change and will disadvantage affected businesses. This also highlights the concern about imposing time levels on divisional applications, and the time limits set by the new legislation will be highly controversial. Although the Intellectual Property Office of New Zealand recommended them to be filed within 5 years of the original patent application's filing date, IPONS has now recommended implementing a 5-year time limit to applications filed under the previous law, the Patents Act 1953. So, Mr Speaker, it is apparent that this is a legislative clean-up job, and what New Zealand First does encourage is for businesses that find the divisional deadline a gridlock, they should challenge IPONS on the basis of how IPONS say it will apply the time limit. In closing, Mr Speaker, New Zealand First is absolutely not in favour of supporting bad legislation, and this bill is no different. Amendments have been proposed to the Patent, Trans-Tasman, Patent Attorneys and Other Matters Amendment Bill. However, this does still not justify the fact that the government has been forced to do a full turnaround on the bill's original purpose and does not protect the profession itself. Thank you, Mr Speaker.